On the record in file 21-20513-FH, People versus Robert Joseph Matson. We are here today for a hearing on a probation violation, and we are proceeding today by video conference. Mr. Matson is present from Lenawee County Jail. Mr. Matson, my court notes indicated that at the last hearing you waived your right to be represented by an attorney. I am required to advise you at all stages of the proceeding that you do have a right to be represented by an attorney, and if you can't afford an attorney, the court will appoint one for you at public expense. Do you understand that?
I don't think you'd be violating your oath of office, Your Honor, by allowing me.
Mr. Matson, don't interrupt me. The question I asked you is whether you understand that you have the right to be represented by an attorney.
I do understand I have a right to be represented by an attorney or not. Yes, sir.
Okay. You've previously waived that right. As I said, I have to advise you that at every stage of the hearing. So I have to ask you again, would you like to be represented by an attorney at this point?
As I started to say, Your Honor, I don't want the representation. However, I will use the help of handling paperwork due to my means here and having access to certain things in paperwork. I will use your court.
All right, pause right there. This is where the sovereign citizen fantasy kicks into full gear. Matson just implied that if the judge allows him to proceed without invoking some mysterious fighting clause, it would somehow violate the judge's oath of office. Let's be clear. There's no such thing as a fighting clause. It's not in the Constitution, not in state law, not in Marvel Comics. This kind of wordplay is how sovereign citizens try to manipulate the court by throwing around made-up legal jargon, hoping it'll create confusion or force the judge's hand. But Judge Sears, he's seen this movie before. He keeps it. Professional steering Matson right back to reality. Do you want a lawyer or not? It's the courtroom equivalent of parenting a toddler with a law dictionary. And honestly, moments like this show just how patient judges have to be, because while everyone else is ready to move on, Matson is still fighting imaginary dragons made of paperwork and oaths.
Do your paperwork or handle any of that. You have the right to have them represent you or not represent you. So that is your choice.
Not represent me, that's fine then.
All right. So you've previously been arraigned on the probation violation. Do you know how you want to proceed? So your options are you can plead to it if you want, which means you'd be admitting guilt. The other option is that I can set it for a hearing and we can have a hearing on the matter, and then I'll decide based on the evidence submitted at that hearing.
Your Honor, all due respect, I wish, are you working under oath of office today, sir?
Sir, I'm not going to answer these questions or deal with this. We've dealt with you before and your sovereign citizen arguments. I've rejected them all. Sir, do not interrupt me. Do you want to have a hearing or do you want to plead?
I'll take your silence under your oath, Your Honor. Okay.
Do you want to have a hearing or do you want to plead?
I want the hearing. I want to go to trial. I want to go within the 90 days to a trial or sooner.
All right. So Sierra will need about a 1 hour hearing on a probation violation.
As well as I'd like you to have the arresting officers that arrested me on that day. I would like their sergeant.
Here we go again. Matson just demanded a trial within 90 days and wants the arresting sergeant to show up in uniform for context. A probation violation hearing isn't a retrial of the original case. The only issue is whether he followed the conditions of his probation, like reporting to his officer, bringing in officers. Uniforms or random witnesses doesn't matter here. It's irrelevant. But this is what sovereign citizens often do. They try to blur the lines between their old case and their new one, hoping to reopen settled matters. The judge calmly explains this, but Matson's not listening. He wants his day in court to argue about things that don't even apply anymore. And let's be real when he says any state police sergeant in uniform would do. That's not a legal request. That's a stage direction in a bad courtroom drama. What? Do you think is he deliberately playing dumb, or does he genuinely believe he's found a secret cheat code in the legal system?
It doesn't matter. Judge, whichever is best for the courts, be fine with me.
All right, I think it will go more smoothly if you are here in person, so we will have you in person here from the jail.
All right, exactly what the hearing is going to be on that day?
So you've been charged with a violation of the terms of your probation.
Yeah.
For failing to report. So the hearing is going to be to determine whether or not you failed to report.
Okay, so it's going to be the trial that day.
Correct.
Okay, can I have the state police sergeant there at that trial?
What state police sergeant?
The state police sergeant of the arresting officers on the night of my arrest.
Who are the arresting officers?
I don't remember the exact names. But any state police sergeant in uniform would do.
Why do you want any state police sergeant to be present at the trial?
Just to show how arrests are made, and why they're made, and how they do the determination, how they...
And now, the grand finale of sovereign confusion. Matson claims he's entitled to a jury trial for violating probation, but that's not how the law works. Probation violation hearings are handled only by a judge, because the defendant has already been convicted. Think of it this way. When you're on probation, you've been given a second chance. You're out of jail conditionally. Break those conditions, and the judge decides what happens next, not a jury. Matson, however, seems to think he's back at square one, demanding a full-blown trial with peers and police witnesses. The judge corrects him again, but Matson just keeps pushing. Sovereign citizens thrive on this tactic. Repeat nonsense until someone gives up. Unfortunately for him, this judge has all the patience in the world and a mute button that works perfectly. If you were the judge here, how long would you last before hitting mute? Be honest.
All right, so the issue that the court is going to determine has nothing to do with things that happened during your arrest. The issue is whether or not...
No, it's not about the arrest. It's about the arrest for the violation of probation as well.
All right, the only issue before the court that day is going to be whether or not you reported. So your arrest doesn't have any relevancy to that. So I'm not going to...
I beg to differ, Your Honor. I beg to differ, because the jury is going to be a jury of my peers, and at this time,
sir,
you're not going to have a jury of my peers.
Sir, there's not going to be any jury. You're not entitled to a jury trial on a hearing about violating your probation.
I'm sorry, I misunderstood. I'm pretty sure that last time I spoke to you, you said that I had the right to a jury trial for determining if I was guilty for a violation of probation.
I've never seen you on this violation of probation.
I've seen, there was you. I've seen both of you.
You did not see me last week.
I did.
And so you're not entitled to a jury trial on a probation violation. So again, we will have you back in person on
hold up then. So if I'm not entitled to a trial to determine if I'm guilty or not, this is a criminal court, isn't it?
It's a criminal court where you have already pled guilty to a felony and been placed on probation.
Because I was at risk of dying in this...
I've muted Mr. Matson's device because he continues to interrupt me and not let me finish what I'm saying. Mr. Matson, I was saying that this is a criminal court wherein you have pled guilty to possessing a controlled substance, and you were placed on probation as a result of that. Your sentence was to be placed on probation. Subsequent to being sentenced to probation, there was an allegation that you failed to report in accordance with the terms of your probation. That is an alleged violation of probation. There's no right to a jury trial for a violation of probation, so the court will conduct.
Let me speak to.
I've muted Mr. Matson again because he unmuted himself and interrupted me. We will have you back.
By the end of this hearing, Judge Sears made it crystal clear probation is a privilege, not a playground. Matson doesn't get to rewrite the law just because he doesn't like the rules. His probation violation hearing will move forward without juries, sergeants, or imaginary fighting clauses. This case is a perfect example of how sovereign citizen ideology collides with real-world law. The courts run on facts, not fantasy, and no matter how confidently someone quotes fake legal codes, reality always wins. If you found this case as wild as we did, make sure to hit that like button. Drop a comment with your thoughts. Is Matson trolling or truly delusional? And don't forget to subscribe for more jaw-dropping courtroom breakdowns from Judge Sears' bench and beyond.